The first element that the claimant has to prove for a negligence claim is the duty of care. So let's just have a look at what exactly the claimant has to prove in order to succeed with a negligence claim. Firstly, the claimant has to prove that the defendant owed the claimant specifically a duty of care. Secondly, once he's proven or she's proven the duty of care, that the defendant breached that duty of care by falling below the expected standard of care. And finally, that this breach of duty caused the damage suffered by the claimant. In this very brief explainer, we're going to look at the first element, duty of care. Your very first step as a claimant, in order to prove that there was a duty of care owed to you by the defendant, is to go and look for a precedent. Because by now we've had so many cases looking at different areas or different instances where the claimant averred that there should be a duty of care, that we've got a load of precedents, we've got a load of categories in which it actually has been decided already by the courts that yes, in these circumstances, we've got a duty of care. Now, we can start with Donahue versus Stevenson, which kicked off the whole tort of negligence. In Donahue versus Stevenson, remember that Lord Atkin gave us the wide ratio, which was the neighbor, known as the neighbor principle. The rule that you are to love your neighbor is in law, you must not injure your neighbor. Who then in law is my neighbor? Persons who are so closely and directly affected by my act that I ought reasonably to have them in contemplation as being so affected when I am directing my mind to the acts and omissions which are called in question. In the case, they then narrowed it down to give the narrow ratio, which held that a manufacturer owes a duty of care to the consumer of its product. In this case, Mr. Stevenson, as the manufacturer of ginger beer, owed a duty of care to Mrs. Donahue as a consumer of that ginger beer. So there we had a category. Manufacturers owe a duty of care to consumers, and you can use that as a precedent if your claim is based on the consumption of a product that was manufactured by the defendant. So after Donahue versus Stevenson, we had what we can call a casuistic development of the duty of care, meaning it developed on a case-by-case basis. So we now have loads of precedents from the cases giving us categories where it's recognized that there is a duty of care. For example, Donahue gave us manufacturers owe a duty of care to consumers. We also have from the cases on the slides here, you might want to pause the slide and just have a look, but we've got recognized categories of duties of care owed by road users to other road users, employers to employees, repairers of machinery to the ultimate users of those machineries. In Bouchard versus Home Office, it was held that a prison authority owed a duty of care towards a prisoner that they knew to be suicidal, for example. Sometimes there are also statutes that very clearly state that there is a duty of care under certain circumstances. One of these is the Defective Premises Act, 1972. So just to reiterate, the very first step in a negligence claim is that the claimant has to show that the defendant owed them a duty of care. And the first step in order to do that is to go and look for a precedent that fits the facts of your case. But what if your facts are unique? What if there is no precedent and we have a novel category that hasn't come before the courts yet? In that instance, we apply what is called the Caparo test. This test comes from the case of Caparo Industries versus Dickman. For the facts of that, go and look at the extended lecture that I've uploaded on duty of care. For now, we just look at the 3 questions that you have to convince the court of if you want to have the court recognize a new category of duty of care. Firstly, you have to convince the court that the damages were reasonably foreseeable by the defendant. Secondly, that there was proximity between the claimant and the defendant. And thirdly, that it would be fair, just, and equitable to impose liability. If you've convinced the court of these 3 things, then you've just set a precedent for a new category of duty of care. Just take note, it's been confirmed by the Supreme Court in the case of Robinson versus the Chief Constable of West Yorkshire that we don't need to reinvent the wheel every time by applying the Caparo test every single time to prove duty of care. It's only if there isn't a precedent or even an analogous precedent. So it doesn't need to be an exact precedent as long as it's close enough analogous. It's only for novel situations that we apply the Caparo test. Finally, there are some problem areas where the courts are very reluctant to impose a duty of care. Chief of these are public bodies, the police. It's been established since the case of Hill and Chief Constable of West Yorkshire, that was the Yorkshire Ripper case, that the police do not owe a generic duty of care to individuals. However, this does not mean that the police have blanket immunity. Their immunity, or it's going to be very difficult to prove that they owe a duty of care towards a specific person unless they explicitly assumed responsibility towards that person. But if the police themselves had created a danger to the individual, as they did in the case of Robinson and Chief Constable of West Yorkshire, then the court would be willing to accept that there was a duty of care owed to an individual. With regards to other public bodies, similarly, the courts have found that social policy issues are not justiciable. The leading case on this is X and Bedfordshire County Council. This was the case where children were, for example, but not diagnosed with learning difficulties or were not taken into care. And they then sued the local council, but the court said there wasn't a duty of care. This really boils down to the fact that what we're talking about here are omissions, failures to act, failure to diagnose something, a failure to take the children into care. And you'll remember that in tort, you're usually held liable for what you did do, not for what you did not do. So there's no general liability for omissions, which is what is generally what people complain about when they complain about public bodies, failure to act. And that explains the difference between the decision in X and the decision in Barrett versus Enfield London Borough Council. In this instance, the claimant was placed in care and while in care was abused. And the court in that instance granted the claim because the claim was about what actually happened. So the actions taken by the defendant rather than the omissions by the defendant. Just to wrap things up, with regards to the first step in establishing your negligence claim, the claimant has to prove that there's a duty of care. How to do that? Firstly, go and look for a valid precedent. If there is a precedent from a case or a statute, and there's a very high likelihood that there would be from case law especially, if you can find a valid precedent, then you've cleared the first hurdle. You've proven that a duty of care exists, as long as your claim falls within that category. In the unlikely event that you cannot find a precedent, in other words, it's a new or novel situation, we then use the Caparo test, where you have to get 3 out of 3 for the following 3 questions. Was the damage foreseeable? Was there proximity between the claimant and the defendant? And finally, is it fair, just, and reasonable for a duty of care to be imposed here? If you've got 3 out of 3, then you've just established a new precedent and a new category of duty of care. If you get 2 out of 3 or 1 out of 3, that's not enough, and there's no duty of care, which would also mean no claim in negligence. So that is it for a very brief recap of the first element to prove in a negligence claim, the duty of care.